Daycare child abuse lawsuit in New York. What parents need to know after the SUNY Cortland case. Attorney Andrew M. Stengel. In May 2026, four employees at the SUNY Cortland Child Care Center faced criminal charges for endangering the welfare of children in their care. According to CNY Central, court documents and a civil lawsuit describe a teacher who locked a 3-year-old in a bathroom for approximately 20 minutes. That same teacher allegedly instructed other children to kick and stomp on a toddler who was on the ground screaming. Another worker reportedly kicked a 2-year-old and aggressively grabbed children by their wrists and arms. These are not accidents. They are intentional acts of cruelty against children who had no way to protect themselves. Criminal charges and a $10 million civil lawsuit. 3 workers pleaded not guilty at arraignment in Cortland City Court in June 2026, according to CNY Central. They are Kelsey Carlisle, Heather Hurto, and Amy Wyatt. Wyatt faces 4 counts of endangering the welfare of a child, plus 1 count of criminal solicitation. Carlisle and Hurto each face 2 counts. Additionally, court documents allege that supervisor and executive director Karen Deeker witnessed the abuse but failed to report it. That failure is itself a serious legal problem. It exposes the institution to significant civil liability. Beyond the criminal proceedings, we filed a $10 million civil lawsuit against New York State on June 1st, 2026, on behalf of a family seeking damages for their 2-year-old child. Daycares owe children a legal duty under New York law. In New York, licensed child care centers must meet standards set by the Office of Children and Family Services, OCFS. Licensing requirements impose direct obligations on facilities to keep children safe. Furthermore, New York Social Services Law Section 413 designates daycare workers as mandatory reporters of suspected child abuse and maltreatment. That means a staff member who witnesses abuse and stays silent may be breaking the law. When a supervisor witnesses abuse and covers it up, the institution's liability grows even larger. Therefore, both individual workers and the organization itself can face civil accountability. 3 legal theories that drive a daycare abuse lawsuit. New York families who sue a daycare after abuse typically rely on 3 legal theories. First, negligent supervision holds the facility responsible for failing to monitor its workers and protect children. Second, negligent hiring means the daycare brought on employees who had red flags in their background. Third, negligent retention applies when management kept an employee on staff despite warning signs. In the SUNY Cortland case, all 3 theories may apply. For example, if the executive director witnessed abuse and did nothing, that is exactly the kind of institutional failure that supports a negligent retention or negligent supervision lawsuit. Additionally, any evidence that management ignored prior complaints will strengthen a family's case considerably. How long do you have to sue in New York? New York law gives most personal injury plaintiffs 3 years from the date of injury to file a lawsuit. In physical abuse cases involving children, however, the clock pauses. Under CPLR 208, the statute of limitations does not begin to run while the victim is under 18. That means a child physically abused at a New York daycare generally has until age 21 to file. Even so, waiting is a serious mistake. Evidence disappears fast. Security footage gets overwritten, employees leave, and witnesses forget details. Therefore, contacting a New York daycare abuse attorney as soon as possible is one of the most important steps a family can take. What a daycare abuse lawsuit can recover. A successful daycare abuse lawsuit in New York can recover several categories of damages. These include pain and suffering, emotional distress, therapy costs, and medical bills for physical injuries. In cases involving especially outrageous conduct, a court may also award punitive damages designed to punish the institution. Most importantly, a civil lawsuit sends a message. It forces institutions to answer for their failures in a public forum. As a result, families who sue often do something important not just for their own child, but for every child at that facility in the future. Your attorney will send a litigation hold letter immediately to stop the institution from destroying evidence. Furthermore, your lawyer can work with investigators, review OCFS records, and identify every party that may share responsibility. In New York, acting quickly gives your attorney the best chance to build the strongest possible case. Contact the law firm of Andrew M. Stengel, PC, today. The law firm of Andrew M. Stengel. PC represents families across New York whose children suffered abuse at daycares, childcare centers, and other institutions. We understand how devastating it is to discover that the people you trusted to protect your child caused them harm instead. Our firm fights aggressively to hold those institutions accountable. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.